Mr Speaker, on Tuesday, on behalf of the opposition, I sought urgency to introduce this bill so that it could pass both houses of Parliament by the end of next week and become the law of New South Wales. At the time, I said that women's safety cannot be risked by more domestic violence offences occurring as this Parliament delays. Unfortunately, the government blocked that urgency, meaning that it is now impossible for changes to the Bail Act to pass both houses of Parliament before it sits again in June, delaying the implementation of protections for women by at least a month. I appreciate those non-Labor members who have agreed to me having priority today to at least introduce this bill and give my second reading speech. In 2 days since I was blocked from introducing this bill on Tuesday, the next day a woman in Alexandria is alleged to have been attacked outside her gym by a knife being thrust into her neck by a man alleged to have had a brief relationship with her. The accused man is a repeat domestic violence offender. Unfortunately, she was not killed, but the incident happened in breach of AVO conditions that the alleged offender not approach the woman. The alleged offender is now in police custody. The Bail Act, which I seek to change with this bill, will come into action the minute that accused man is probably charged today. The added protections that I seek to introduce to the safety of women through this bill would be able to operate if it becomes the law of New South Wales. That is why passage of reform has urgency. Overnight, we heard reports that a man from Riverview has been charged with several domestic violence offences, including allegations that he was tracking a woman's car and breaching an AVO. The police located 2 listening devices and GPS devices during the search of his property. The alleged offender was charged with several offences, including contravening an AVO domestic, stalking and intimidating, and possessing surveillance devices intended for unlawful use. The police will allege that the man had installed the tracking devices in the vehicle of a woman who was known to him. He was refused bail. Unfortunately, it is incumbent upon us, if we are to truly represent our communities, to properly reflect on these tragic cases and learn from them. If we do not, then we are likely to repeat the mistakes of the past and will be unlikely to craft good laws. The death of Molly Ticehurst in Forbes just 2 weeks ago was tragic. A young woman, a childcare worker, a woman who was murdered where she was entitled to feel safe in her own home, allegedly by a former partner, a man who was on bail, whose bail conditions were meant to prevent him from being in the same town as her, but whose bail conditions alone allegedly could not stop this tragedy. The police allege that Molly was murdered in Forbes in breach of bail conditions. At the moment, there is no electronic monitoring of bail conditions. This needs to change. 15 days prior to Molly's alleged murder, bail was granted to the person charged with her murder, and he was charged with 3 charges of sexual intercourse without consent, 4 counts of stalk, intimidate, 2 charges of property damage, and 1 count of cruelty to an animal, being Molly's dog. I spoke about the death of Molly Ticehurst in some length in this chamber on Tuesday, and I do not need to repeat what I said. But the greater tragedy is that these 3 incidents that I've spoken about this morning are not isolated. According to DV New South Wales, our police officers attend a domestic and family violence call approximately every 2 minutes. And in 2023, 64 women were killed by violence. These are not just figures, these are mothers, daughters, sisters, aunts, friends, loved ones, and their tragedies urge us to continual action to improve the status quo. The murder of Molly Ticehurst should galvanise this Parliament to act in relation to domestic violence, but of course act in a way which is proven and capable of effecting real reform. Which is why I seek Parliament's support for this bill. It is an appropriate response, not a knee-jerk reaction. Of necessity, it is a partial response because we know that sadly Molly's death is not an isolated incident, but a symptom of an ongoing malaise within our society, and this measure addresses only some of the drivers. Of course, we must continue to work to find a solution to the scourge of violence against women, but we must also do what is possible now. I recognise that the government has ordered 2 reviews arising from the death of Molly Tysus, which are due to be completed in some weeks' time. And information gathering and reflection is important, but there are also concrete actions which we can take immediately, concrete actions building on the work done by the previous coalition government in relation to electronic monitoring for parole, introduced in 2016, reviewed by the Bureau of Crime Statistics and Research in May of 2023. The parole system of domestic violence electronic monitoring was found to be a highly successful measure to reduce reoffending, reduce breaches of parole conditions, and reduce breaches of ADVOs. Bail conditions are typically very similar to parole and ADVO conditions. They include conditions that the person shall not approach the victim or their home or place of work. This legislation builds on this earlier work and evaluation and makes a positive contribution to women's safety now. Under the domestic violence electronic monitoring for parole, which we want to extend to the grant of bail, a government-supervised system monitors if the person on parole moves into a place they are not allowed to under the conditions of parole. If they do, they are contacted and told to comply with the parole conditions. If they are monitored to not respond appropriately and rectify their breach, then the police and participating victims are informed. Victims can then enact their personal safety action plans. Because of the distances in regional and peri-urban areas and the lack of density of police per kilometre of area in those communities compared with cities, this will be a significant improvement over the current system of bail conditions where nobody monitors where there is compliance with the conditions of bail and nobody notifies the participating victim where there is a breach. Too many women are being harmed under the current system. It's time to have a system which uses technology to measure the compliance with the conditions of bail and warn victims when they are not. This will not be a perfect solution, but it's important that we immediately implement all the improvements that have been shown to work, like electronic monitoring, into the system. There may be other improvements to the bail system that the Crown Advocate suggests as part of the 2 government reviews, but it is, as a matter of reality, very unlikely, given the positive evidence from the parole monitoring, that the Crown Advocate would argue against what we are proposing. We must not let the perfect be the enemy of the good by delaying what positive actions we can take now because there are more actions to be taken in the future. Going now to the bill in detail, it makes 3 changes to the Bail Act which can immediately improve women's safety. Its immediate passage will ensure the quickest possible implementation and improved protection for women. At the core of this bill is the introduction of electronic monitoring as a presumed bail condition for all serious personal violence offences within a current or former domestic relationship where either the prosecutor has called for this as a condition of bail or has made an application that bail should be refused. Those closest to the victim and to law enforcement need to be heard about their assessments as to the risks of bail. We know that it's not enough for the offenders to be told to simply stay away. We need the means to track compliance with the bail conditions, and especially relevant to women's safety is where offenders are breaching location conditions. Electronic monitoring will provide this ability. Sadly, recent events have told us that without the backup of electronic monitoring, compliance with bail conditions is not measured and is unacceptably up to the good behaviour and voluntary compliance of the perpetrator. Specifically, paragraph 3 of Schedule 1 of the bill will introduce a new section 22D into the Bail Act. This imposes the presumption that bail can only be granted for serious personal violence offences on condition of electronic monitoring. This will apply where the alleged victim was or is in a domestic relationship with the accused, who must be over the age of 18 years. In addition, either the bail application must be opposed by the prosecutor or the prosecutor has requested electronic monitoring as a condition of bail. In addition, it is clear that a bail authority can impose electronic monitoring for any other cases which fall outside of that presumption because of section 22, capital D, subsection 3 of the new provision. In answer to the ill-considered points raised by the Leader of the House and the Minister for Local Government in this House on Tuesday, that the proposed serious personal violence offence definition in Clause 1 of Schedule 1 of the bill is too limited and did not include offences like strangulation, there are several answers. Firstly, the bill does not limit electronic monitoring to serious personal violence offences and can apply to bail on any offence as the proposed new section 22, capital D, subsection 3 of the bill makes clear. It is only the presumption, like the current show cause presumption under section 16, capital B of the Bail Act, that hinges on the definition of a serious personal violence offence. Secondly, the definition of a serious personal violence offence for my bail amendment is exactly the same definition as in the current section 16, capital B, subsection 3 of the Bail Act, and has been the definition of the Bail Act of this state for many years, which I would have expected the Leader of the Government in this House to know. We are flexible and open to consider government amendments to expand the presumption in the bill to offences beyond the current definition of serious personal violence offences. The current definition used in the bill has been the law in this state for many years, but such a change to that definition will not expand the cases where the electronic monitoring is able to be ordered as a condition of bail. It will only expand the cases where there is a presumption of electronic monitoring as a condition of bail and where there are show cause cases. I repeat and emphasise, electronic monitoring can be ordered under section 22, capital D, subsection 3 within the bill with respect to any criminal offence, whether it be coercive control, strangulation or otherwise, and not just serious personal violence offences in a current or former domestic relationship. I should also point out that the definition of a domestic relationship under the proposed new section 22D subsection 4 of the bill has the same meaning as under the Crimes, Domestic and Personal Violence Act 2007, which in section 5 of the Act is defined to include, and I will just read section 5 of that bill that Act very quickly. Subsection A, subsection 1 little a, is or has been married to the other person, or is or has been in a de facto partner of that other person, or has had an intimate personal relationship with the other person, whether or not the intimate relationship involves or has involved a relationship of a sexual nature, or is living or has lived in the same household as the other person, or is living or has lived in a long-term resident in the same residential facility as the other person, or has had a relationship involving his or her dependence on the ongoing paid or unpaid care of the other person, is or has been a relative of the other person, and so on. Subsection 2 is that two persons also have a domestic relationship with each other for the purposes of this Act if they have both had a domestic relationship of a kind set out in subsection 1, little a, b or c with the same person, which means that the ex-partner and current partner would therefore have a domestic relationship with each other for the purposes of the Act. The bail system is an integral part of the justice system and an important practical recognition of the doctrine of innocence until proven guilty. It also, though, balances the rights of the accused with the need to protect any alleged victims. This bill rebalances the scales of justice and importantly and necessarily recalibrates the balance between the rights and protections in favour of protections. Presumptive electronic monitoring, which this bill imposes, and the new section 22D subsection 3 also ensures that it can be imposed by bail authorities in other circumstances, will achieve this protective rebalancing. If the accused has no intention of breaching bail conditions, then the monitoring provides no infringement of their freedom of movement, But if they do intend to breach bail conditions, then the police need to be able to intervene to protect the woman, and the victim needs to have a good warning to be put in place so that they can enact their personal safety action plan. Electronic monitoring of offenders is not new ground. It operates successfully in other contexts. It's not a knee-jerk reaction, rather a common-sense approach to protect women. Going to paragraph 4 of Schedule 1 of the bill, it makes amendments to ensure that the powers of the bail authority encompass the ability to require electronic monitoring as a condition of bail before the offender is released. This is a necessary ancillary amendment to Section 29, subsection 1 of the Bail Act to allow for the imposition of electronic monitors prior to release as a specified requirement identified in the decision of RVZ reported in 2015 New South Wales Supreme Court decisions 1575 at paragraph 37. The second major change under the bill is in paragraphs 5 and 6 of Schedule 1 to the bill, which expands the existing provisions of Section 40 of the Bail Act to allow for the decision of a court or authorised justice to grant bail to be stayed in circumstances where the bail conditions referred to in the new Section 22, capital D, subsection 2, have not been imposed, and the prosecution immediately indicates to the court that an appeal by way of a detention application is to be made to the Supreme Court. This is an important provision because it continues to protect a victim if electronic monitoring was sought but not ordered until an appeal can be determined. While an urgent hearing is being heard, the offender will continue to be detained for up to 3 business days until the appellate process, if engaged, is urgently concluded. The third major change made by this bill is made in paragraph 7 of Schedule 1 to the bill. This paragraph provides that important decisions in relation to bail for serious personal violence offences in domestic relationships can only be made by appropriately qualified judicial officers. This change will ensure that a registrar of the local court cannot hear a bail application for a serious personal violence offence. This is the job of magistrates. It's a simple change, but it is significant, because in effect it allows only judicial officers to make bail decisions in the case of a serious personal violence offence. This is not to disparage the work of court registrars, but rather it locates responsibility for important judicial decisions regarding liberty and safety in the appropriate place. A serious personal violence offence, as the very name suggests, is not something to be taken lightly. In fact, the definition provided for within the bill defines a serious personal violence offence as an offence which is punishable by imprisonment for a term of 14 years or more, or similar offences. As such, the possibility of danger to the alleged victim and the community at large is real and needs to be considered carefully. It is a decision properly made by a judicial officer as part of their role in the administration of justice, and not an administrative or clerical matter which ought to be decided by a registrar. I note that we do have the audio-visual equipment in our courts already which will allow magistrates to make these decisions remotely, and so this change should not present a resourcing issue for the operation of the courts. By the expansion of electronic monitoring in bail cases and the use of only magistrates for bail in certain circumstances will have some practical consequences, so a period to implement these changes will be necessary. This has been accommodated by a delayed commencement of no more than 6 months. That is a clear message to the government that it needs to organise these changes quickly. By Parliament passing this legislation quickly, the clock will start ticking. Delay in these circumstances can cost lives. As another domestic violence attack occurred yesterday, I reiterate my words on Tuesday that speed is of the essence for this Parliament to start electronic monitoring of bail conditions. We are not claiming that this bail will end violence against women or that it does anything to address the root causes of this issue, such as problems around alcohol and drug misuse, gambling, ready access to violent and misogynistic pornography, and a host of other issues which feed into domestic violence. What this bill does do is enhance protection of those women who are already victims of these social ills, the women who have come to us for help, who are seeking justice and who need our protection from those persons that would threaten them. This bill is a first step. It builds on proven technology, and it is a step that we can make today to reduce the tragic outcomes of domestic violence. I urge this House to support the bill before more domestic violence charges become murder trials on the back of unenforceable bail conditions. When we announced this policy on Tuesday of last week, we said we are wanting to work in a collaborative manner to improve women's safety. We are open to any suggestions to improve the bill, and we will work with the whole of Parliament to improve women's safety. I commend the bill to the House.